On February 24, 2018, Belcalis Almanzar, the rapper known as Cardi B, was involved in a heated confrontation with a security guard at a Beverly Hills medical plaza. The encounter led to a civil lawsuit filed by Imani Ellis, who alleged that Ms. Almanzar committed assault and battery by scratching her face and spitting on her during a visit for prenatal care. While the defense maintained that the interaction was purely verbal, the plaintiff sought $24 million in compensatory and punitive damages, citing physical injury and emotional distress under California Civil Jury Instructions 1,300 and 1,301. These instructions require the plaintiff to prove by a preponderance of the evidence that the defendant intended to cause harmful or offensive contact. On August 28, 2025, Dr. David Fink, the OBGYN, who was treating Ms. Almanzar at the time of the incident, was called by the defense. After defense counsel Peter Anderson completed his direct examination, the plaintiff's lawyer, Ron Rosenjan-Faza, conducted the cross-examination.
Good afternoon, doctor.
Good afternoon.
You're at 8920 Wilshire Boulevard?
Yes.
Are you aware that I'm across the street from your office at 9025 Wilshire Boulevard?
Nope.
Okay. When I approached you outside and I wanted to speak with you, isn't it true that you were unwilling to speak with me? Is that correct?
Yes.
Okay. And when the defense wanted to speak with you, you did talk to them, correct?
Yes.
You even prepared a declaration, and you gave them permission to sign it on your behalf?
Yes.
And you are here because you want to testify in favor of your patient, correct?
I'm here because I'm one of 4 people who were in the hallway that day.
Right.
And I'm here to tell you what I saw.
And you've been, I'm sorry, go ahead.
And I'm just flabbergasted by the allegations that don't seem congruent with what I saw that day.
Right. On how many occasions did you speak with the attorneys from the defense?
In person or over the phone?
Combined.
In person once, twice, including today. Over the phone 3 times.
What did you talk about that was so important 3 different times?
They wanted to know what I knew. They wanted to see if they could get a hold of Tiara, who no longer works at our practice. That's the nuts and bolts.
Okay. You are a licensed gynecologist in the state of California since 2007?
Yes.
In your field, your specialty deals with below the waist, correct?
Yes.
What is the reason you would think to look at Imani Ellis's face when you have 2 people that are yelling at each other with someone in between? Was there a reason that you were specifically at that time looking at Imani Ellis's face to tell us whether there was a scar, a cut, or anything to her face?
When at that moment, she was closer to the elevator. There probably was about 3-4 feet between the 2. And I got between her and them. And the elevator was directly behind her. So I was making direct eye contact to try to be as assertive as I could.
Okay. Isn't it true that you don't remember what you ate a week ago? Fair?
Objection.
This incident happened 2,741 days ago, 7.5 years ago. You agree?
Correct.
In those 7.5 years, did you take any notes of what happened on the date of the incident?
I did not.
Okay. So everything you're telling us right now, from 7.5 years ago, is from your memory of what occurred, correct? And
Correct.
Having all these conversations with defense counsel maybe help refresh your recollection, correct?
No.
No?
The majority of solidifying it in my brain over all these years is partially because the people who were involved in it, who were there that day in my office, would recount the story from time to time. And it was a very vivid memory and interaction.
When you got there, Tierra Malcolm, your receptionist, was already outside, correct? Okay.
Yes.
Are you aware that Tierra Malcolm and even Cardi B have testified that for 40 to 50 seconds, you and Tierra Malcolm were not there? Are you aware of that?
Objection is characterized as the testimony.
I would guess it was shorter than that, but if their recollection is 40 to 50 seconds, I mean, as long as it takes me to go down the hallway and out into the hall, the type of yelling that was taking place was alarming, and so it was like, get there right away. I can't give you an exact time frame, but it wasn't more than 40 to 50 seconds.
During cross-examination, Mr. Fink testified that he was flabbergasted by the allegations in the case, asserting that the claims were not consistent with the scene he personally witnessed in 2018. He admitted to communicating with the defense team on 3 separate occasions over the phone and to providing a signed declaration, yet he confirmed that he had taken no written notes regarding the incident in the 7.5 years since it occurred. When questioned about the reliability of his memory across that span of time, the doctor maintained that the event remained vivid in his mind because he and his office staff had frequently recounted the story over the years. Under California Evidence Code 780, the jury is tasked with evaluating the credibility of a witness, specifically considering their capacity to recollect matters and any bias, interest, or other motive. When a witness relies solely on memory for an event occurring years prior without the support of medical records, their testimony could be considered susceptible to recollection bias. By highlighting a witness's refusal to speak with one side of a case while maintaining frequent contact with the other, attorneys aim to demonstrate to the jury that the testimony may be influenced by partisan interests rather than objective fact. This ensures the jury can properly weigh whether a witness's claim of a vivid memory constitutes a reliable account of the truth or a narrative that has been gradually...
But you had not gotten there until after many things occurred between the two of them, correct?
Objection calls for speculation. Facts foundation.
Sustained.
Earlier you testified that you saw Imani Ellis hit your receptionist.
Yes.
You remember seeing that?
Yes.
How come your receptionist didn't say that?
Objection is
Sustained.
Are you aware that your receptionist who was facing Imani Ellis did not say that?
objection.
Are you aware of that at least?
I'm not aware of that.
Did your receptionist ever tell you that Imani Ellis hit her?
Yes, in the recollection of everything back and forth, and then she had a thing on her forehead.
Right.
It was very apparent to me that no hits landed on anybody else except for her,
Okay.
my receptionist.
And your receptionist specifically told you that Imani Ellis hit her, correct?
I saw it.
I understand. But did your
I
receptionist
don't know
tell
that
you?
she remembered it. I mean, I don't. Everyone's adrenaline was kind of elevated. And once, we kind of recounted, there's some background as well. We had an attorney visited our office a few times in the weeks after the incident, inquiring what happened and various things, leaving a business card. So we talked about it a lot, and I think we both concluded that the only one who was smacked was her.
Did that receptionist make any type of claim against Miss Imani Ellis?
No.
Why not?
Objection calls for speculation.
Sustained.
In your declaration, you state that on one occasion, plaintiff's counsel left a business card. I'm the plaintiff's counsel. Did I leave a business card in your office?
Objection, Your Honor.
Do you know? I withdraw the question. Do you know if I left a business card in your office?
Objection calls for speculation.
Overruled.
You personally, I do not. It was a male, dark hair, darker beard, and a different receptionist got the business card, who wasn't working that particular Saturday. And I think at one point I came out on a different occasion when this person was came to the check-out desk, not the check-in desk. on a different date, and I said, you need to leave.
Okay. The declaration that you signed yesterday, have you read it?
It was read to me.
Okay.
Your Honor,
Mr. Fink further testified that he personally witnessed the plaintiff, Ms. Ellis, struck his receptionist, Tiara Malcolm, during the encounter. Mr. Fink maintained that the receptionist sustained a visible mark on her forehead as a result of the altercation. Mr. Genfaza suggested his testimony was motivated by a desire to protect a high-profile celebrity client. The doctor rebutted the claim of partisan bias. Under California Evidence Code 780, an attorney may attempt to impeach a witness by demonstrating a financial or personal motive to testify untruthfully. However, the jury must ultimately weigh the witness's demeanor while testifying and the consistency of their statements against these allegations of bias. Mr. Genfaza also inquired why the receptionist had not filed her own lawsuit against Ms. Ellis, prompting an immediate objection for lack of foundation and speculation. The judge sustained the objection because the question violated California Evidence Code 702, which requires a witness to have personal knowledge of the subject matter. Witnesses are generally prohibited from offering lay opinions regarding the internal motives or legal strategies of third parties.
Can you look at the photograph in front of you?
could you identify it to counsel, please?
Do you see the photograph?
Can you identify for the record, counsel?
I'm sorry, Your Honor, I don't remember the exhibit number, but it's a photograph of Cardi B from 2018.
Your Honor, it's exhibit 232.
Thank you.
Okay. For the record, exhibit 232. You see the photograph?
I do.
Are you aware that this photograph was taken on February 18th of 2024, which was 1 week before
Objection,
the
Your
incident? Are you aware of that?
Objection, Your Honor.
Sustained.
Do you know when this photograph was taken?
Objection, Your Honor.
Overruled.
No, but it probably was around the time of the incident, I would guess.
And may I have it back, sir? If you look at the fingernails, since you're a fingernail man, if you look at these fingernails in the photograph, and sorry, I wasn't trying to be rude, I'm just making a joke. If you don't
Fine.
mind. The fingernails that are in this picture, are these the same fingernails that Cardi B was wearing when she entered your office on the date of the incident?
I think so.
Are you sure?
I didn't memorize them, but I know that they weren't 3-inch long with a spear at the end.
But you're not sure if these are the same fingernails, correct?
I believe they are.
Was Cardi B's hair this way when she came to your office, the same way in this photograph here?
Objection, relevance.
Sustained.
Scope.
Was Cardi B dressed this way when she appeared in your office?
Objection, relevance.
Sustained.
Scope.
When you came out into the hallway, did you hear Cardi B yelling profanities at Miss Ellis?
Yes.
What were some of the words, without going into detail? The F word? The B
F's
word?
and B's and all of it.
So both sides were yelling at each other?
It was an epic yelling match.
Okay. And when you heard this epic yelling match, it was so loud that you heard it while you were inside of your office? Is that correct?
There's an additional hallway in between the main hallway and the office I was sitting in. And all the way at the south side of the building. It, yes, took a lot of energy for me to hear it.
When you walked out of your office, you didn't know what areas of the body Miss Imani Ellis was claiming injuries to at the time, correct?
Objection.
I withdraw it.
Why not just ask him a fact check question?
Do you know what areas of the body Imani Ellis, what areas of her body were injured at the time of the incident?
Objection, argumentative, lacks foundation, contrary to all the evidence in the case.
Sustained.
Did you have a reason to focus on any part of Imani Ellis's body when you came out?
No.
So, in your state of mind when you walked out, you heard lots of screaming, 3 different women doing something, and you were focused at the whole thing, weren't you?
Yes, that was before I asked her to leave multiple times,
Of course.
but face to face.
Right. But when you did come out, you saw 3 different women and your receptionist in between Cardi B and Imani Ellis, correct?
Yes.
And when you were facing that, your focus was not only at Imani Ellis, it was at everybody, correct?
Yes.
Okay. And there was a lot of commotion and yelling and screaming and excitement at that very moment, right?
Correct.
And for how many seconds, when you first arrived, how much time passed before Imani Ellis went away?
It seemed like a long time. It probably was 45 seconds.
So in those 45 seconds, did you have a chance to examine Miss Imani Ellis?
I didn't examine her, I looked at her.
Okay. Did you specifically look at her face for some reason?
I was looking directly at her face for at least 20 seconds or so,
Okay.
repeating myself over and over and over.
Right. And when you were doing that, you weren't looking for a scar, were you? Or a cut or any kind of damage to her face?
Objection asked and answered.
Sarah?
Sustained.
Do you have any experience in plastic surgery?
Objection development.
You may answer, doctor.
Define plastic surgery.
You're the doctor.
I do cosmetic procedures on the vagina, the vulva, and I also do microneedling with radiofrequency procedures, CO2 laser ablation of things. I don't do the face.
Understood. So, if there was any damage to Miss Imani Ellis's face, if there was any kind of injury to it, would you have known?
I would assume I would see blood or a big scrape or some physical damage.
And when you were out there and you were between the 3 of them, the 3 women, when you were there, and in those 45 seconds, did you see the cut to your receptionist's face at that time, not later?
No,
You didn't see it.
I never looked directly at her until we were back in the office.
But at that time, it was there, right? During the 45 seconds, it had already...
Well, sometimes little scratches like that might not show up for a little bit.
What's a little bit?
Well, if I just scratch my hand like this, I might see it out in the sun, 10 minutes later from just erythema.
Okay. So if Imani Ellis got a scratch, she could also develop it 10 minutes later. Fair? You just testified to that. Isn't that true?
Counsel to tell us what he testified to, but I would object, Your Honor. Mischaracterized testimony.
All right, why don't we ask what this witness knows about the incident?
Mr. Genfaza challenges Mr. Fink's observation that no visible injury was present on Ms. Ellis's face. During this exchange, the attorney focused on the doctor's admission that a scratch might take up to 10 minutes to fully manifest. This line of questioning directly addresses the probative value of immediate observation. By securing the admission that symptoms can be delayed, counsel sought to establish that the absence of a visible mark during a brief 45-second observation does not forensically or medically preclude the existence of an underlying injury. Furthermore, Mr. Genfaza attempted to undermine Dr. Fink's competency as a witness regarding facial injuries by highlighting that his surgical expertise is concentrated in gynecological anatomy. Under California Evidence Code 720, while a physician is generally qualified to testify, an attorney may challenge the foundation of their opinion if the subject matter falls outside their specific field of practice. By narrowing the scope of the doctor's expertise, the attorney argued that while the doctor's testimony was admissible, it should be given minimal weight by the jury when compared to the specialized knowledge of a dermatologist or plastic surgeon.
When you spoke to defense counsel 3 times, which attorney was it? Was it Mr. Anderson or Mr. Lamb or Ms. Moore?
Over the phone, Ms. Moore.
Every time?
Probably, yes.
And for you to come down here and testify, you had to at least cancel half the day of your work, correct?
I canceled my whole afternoon on a day's notice.
Okay. Are you getting paid to be here?
No.
Why are you testifying if you're not being paid? Were you subpoenaed?
I was not.
So you came voluntarily.
I did.
And they believed that you would appear here today in court with no subpoena. That's how confident they were that you were here to help them, correct?
Sustained. Any other questions?
When Cardi B came into your office after the incident, what did she tell you?
I apologized. She was more calm than I thought she would be. She didn't complain about the incident or to me afterwards, which I was kind of surprised about as well. I would have been upset if I were the client. And then we proceeded to help her with what she came in for.
Could it be that she didn't apologize because she was the one that assaulted Miss Ellis?
Objection, Mrs. Speaker.
Sustained.
Did you
How
have...
about stopping with the could it be's and just ask him what happened, what you saw, what you heard, what he smelled?
Yes, Your Honor. Can you look at the photograph again? The one that you have in front of you, Exhibit 231 or 232? This one. In the photograph, you will see nails, fingernails with some rhinestones on top of them. Do you remember seeing rhinestones on Cardi B's fingernails when she came into your office on the date of the incident?
Objection, mischaracterizes the evidence and the photograph.
Over.
Yeah, I mean, they were decorative. She was not made up. She was in plain clothing, but she had, the nails were done.
And those rhinestones, were they sharp and pointy?
I think rhinestones in general have rough edges.
And they're sharp and pointy and with rough edges?
On the back, on the front side of the nail, on the top of the nail, they look like they project.
And I see that you're wearing glasses. Do you wear them? Were you wearing your glasses at the time of the incident?
I'm 99% sure I wasn't, because up until a couple of years ago, I just wore contacts.
Were you wearing contacts at the time of the incident?
Yes.
So there was no vision issues.
No.
I have no further questions. Thank you, Doctor.
All right, rewrite.
Mr. Genfaza argued that Mr. Fink's voluntary appearance and his decision to waive financial compensation signaled partisan bias toward his patient. While expert witnesses are typically compensated for their time, a precipient witness who appears without a subpoena and waives fees may be scrutinized for friendly witness status. Furthermore, the cross-examination addressed the alleged instrumentality of the battery, specifically the rhinestone-encrusted fingernails depicted in Exhibits 231 and 232. To establish the prima facie elements of battery, the plaintiff must prove harmful or offensive contact. By pressing Mr. Fink to concede that the rhinestones possessed rough edges, Mr. Genfaza tried to build a foundation for circumstantial evidence. Finally, counsel challenged the reliability of perception by questioning Mr. Fink's use of corrective lenses. Under California Evidence Code 780, the weight of testimony depends on the witness's capacity to perceive the event. Although Mr. Fink appeared in court with glasses, he was locked into his testimony that he wore contact lenses and had no vision impairment in 2018. On September 12, 2025, Ms. Almanzar was cleared of all allegations, assault, battery, and intentional infliction of emotional distress. The core claims from the original lawsuit were not sustained at trial, including the specific allegation that she had physically scratched or spat upon Ms. Ellis during the 2018 encounter at the medical building. Following the jury's unanimous verdict, Judge Ian Fusselman entered a judgment in favor of the defense, finding no liability for the alleged physical confrontation. With the jury's determination that no harmful or offensive contact occurred, Ms. Almanzar was absolved of any financial obligation to the plaintiff, effectively ending the 7-year legal dispute. This case illustrates the critical importance of witness credibility in civil proceedings and the judiciary's role in managing high-intensity cross-examinations. The court's intervention during the yelling match ensured that the jury could distinguish between aggressive advocacy and the objective facts of the 2018 encounter. By upholding the integrity of Mr. Fink's testimony among other witnesses, the court reinforced a fundamental principle of evidence, that a witness's capacity to recollect a landmark event is a valid basis for testimony under Evidence Code 702. Ultimately, the jury's decision to clear Ms. Almanzar of all charges reflects a recognition that a verbal altercation, however heated, does not warrant the imposition of millions in damages without proof of harmful or offensive contact. This outcome underscores the vital function of judicial oversight in safeguarding defendants against speculative litigation and maintaining the integrity of the civil justice system when faced with high-profile allegations. Now, let us know if there is a case you would like us to explore in the comments below. Thank you for watching, and don't forget to like and subscribe so that we can help promote a more informed society.